committees.
And you can have it all with your membership in the Greater Bakersfield Chamber of Commerce.
This is Strictly Business, presented by the Greater Bakersfield Chamber of Commerce. Sponsored in part by the law offices of Young Wooldridge, San Joaquin Community Hospital.
And welcome back to Strictly Business. I'm Nathan Ollie, Manager of Government Affairs at the Greater Bakersfield Chamber of Commerce. And joining me today in our Spotlight segment is Jay Rosenlieb of Klein DeNatale Goldner. And we're going to talk about the most common types of employee lawsuits and what employers can do to protect themselves. So thanks for joining us, Jay. Appreciate it.
Thanks, Nathan. Appreciate it.
Sure. So what are some of the most common types of lawsuits that employees are filing these days?
Well, I tell you what, there are a lot of them. We track the filings in 9 different counties here in Central California. And what we see is discrimination, harassment, some retaliation, some whistleblowing, but mostly dealing with wage and hour as well as class action wage and hour.
Oh, okay.
So those are the topics.
Well, let's start with discrimination. What can lead an employee to reach the level where they feel like they need to file a lawsuit? What are some of the common discrimination suits that we're seeing?
The common discrimination lawsuits are going to be maybe the racial discrimination, gender discrimination. The subset of that is harassment, and sexual harassment is what we see most often. And those lawsuits can be they can be sad, they can be outrageous, or they can be someone just doesn't like the way that the boss treated them, but it's not legally actionable, and so they decide to sue.
Okay. So are there acts that can like discrimination lawsuits, are there some acts that can protect the employer from an outrageous lawsuit or a frivolous lawsuit? Are there some kind of protections in place?
Sure. What we advise clients to do is to certainly document at all times. To have good, strong policies in place that are going to make it clear to everyone involved that discrimination is not to be tolerated.
Sure.
Discriminatory acts are not to be tolerated, and that if an employee feels that they are being discriminated against, they have the right to report that to management or to the owner of the company to make sure that it's addressed. A lot of this all deals with communication, and the forward-looking company is going to engage not only in documentation of everything, but they will also make sure that they fully and adequately communicate with their employees at all times. Discrimination lawsuits very often begin with a misunderstanding of some kind or another, and so the good, strong business is going to make sure that there aren't misunderstandings and that there's clear communication of expectations and why certain business decisions were made.
Okay. You mentioned having, as part of the communication strategy, you mentioned strong policies and things like that. Is there specific language that would need to be included to protect an employer, or is it just a case of we don't tolerate discrimination based on certain... Is there specific language involved?
Well, I wouldn't say there's so much specific language that's involved. What I would say is that there is... we don't tolerate discrimination, so that everybody knows from the beginning, from the your most senior employee to your most junior employee, from your highest level of management to the folks who are working out on the line, that everybody knows that discrimination is not tolerated. What you're doing there then is creating a culture that we don't.
It's just not the way we operate.
Correct.
Okay.
It's not the way that we operate, and that folks are going to rise and fall based on merit, productivity, quality of their work, as opposed to some other, quite frankly, irrelevant criteria.
Okay. You mentioned age or gender discrimination. I'm sure age discrimination would be another example of those kind of things.
Yeah.
Perhaps in the hiring process. How would you? What are some ways that you can sort of head that off at the pass? I mean, if you're doing a hiring and the person's not in your organization, they may not be subject to your organization's policies. What are some ways in the hiring process that you can kind of head those things off at the pass?
Well, you want to make sure that the folks within your organization who are looking at the resumes, who are screening the resumes, who are doing the interviews, are folks who, quite frankly, aren't interested in some of these areas where discrimination might take place: age, sex, race, religion, national origin, medical status, veteran status, etc. And so you want that, again, to use the phrase again, that cultural piece to be in there, that folks are not interested in that. There are certain questions that you're not allowed to ask in interview settings. For example, gosh, I see you have a bunch of kids. How are you going to care for them?
Okay.
Or, gosh,
how old are you?
How old are you? Or,
Okay.
gosh, I see you have a bunch of kids. Are you married? Questions like that are completely inappropriate.
Okay.
So, again, make sure that your folks are trained on which questions to ask and to ask job-relevant questions. Ask them about their skills. Ask them about their experience, but not get into areas that are extraneous.
Okay. So let's talk a little bit about retaliation. You mentioned retaliation and whistleblowing.
Sure.
What is that? Give us an example of something that we might commonly see.
An example of that would be a situation where, you have an employee who feels that they haven't been paid correctly, or they, and so they file a claim against you because they believe that they haven't been paid correctly. Or you have another employee who feels that they have been discriminated against, and so they file a claim against you. And whatever happens to those claims happens. And let's assume that it's eventually found that that employee was paid correctly, and that employee was discriminated or was not discriminated against. Well, some employers, may feel, shall we say, badly that individual filed the claim against the company.
Sure.
And some employers might be inclined or might be interested in retaliating,
Seeking a little retribution.
say we can't have that person around around our business anymore because they, in fact, have acted contrary to the interests of the business. They took up our time. And so they might demote them, they might suspend them, or they might, in the worst case scenario, terminate them. I will tell you this much, that the ugliest case is the retaliation case, because juries tend to get very upset with an employer who has said, gosh, yeah, we understand this person went through the steps, they used the system, and now they're being punished for using the system.
For daring to speak out, really.
Correct.
Okay.
Correct. And so as a result, the retaliation lawsuits, that's where we see some of the biggest verdicts.
Oh, wow. Okay.
And so employers need to make it clear, both in their policies as well as during the investigative process, if it's a discrimination or harassment action, that there will be no retaliation, and retaliation will not be tolerated. And they need to make that clear not only to the complainant, so advising the complainant that, if you are retaliated against, please let us know. But management also needs to make that clear to the alleged perpetrator and tell the perpetrator, you're not going to retaliate against this employee.
Right.
And sometimes that's hard with the people having to go back into the same workplace.
Having to go back to work every day with someone that has sued the company, right? Yeah. So again, documentation, always critical in cases like this.
Yeah, it is. And what you want to do if an allegation of harassment is going on, or an allegation of discrimination is going on, you want to undertake an investigation of that. The law requires that the employer undertake an immediate investigation. What does that mean? It doesn't mean that you wait a week. It means that you get on it right away. We had an employer who came in on Friday of last week, and the investigation is going on right now at my office as we speak.
Okay, wow. So immediately, yeah.
Yeah, an immediate investigation, and you document that. Now you can hire an employer can hire an outside individual, such as a trained investigator, such as an attorney, to do the investigation, or they can conduct the investigation themselves. It is strongly recommended that the investigation be done by someone outside. Why? Well, because that individual is presumably unbiased.
Right.
And so that's not to say that the employer is going to put their biases on the investigation, but they are the employer, and so the claim could be made that, in fact, they are biased.
Okay.
So they need to be unbiased, and they need to be trained.
Okay. In the last couple of minutes that we have here, I know you'd mentioned during the break class action lawsuits that
Yes.
were really one that we're seeing a lot of. So talk a little bit about that, if you would.
Sure. I would say that of the class action or of the lawsuits that are filed here again in the 9 counties in Central California that we monitor, my estimate is that about a quarter to a third of all lawsuits relating to the workplace are class action lawsuits.
Okay.
We see quite a few filed in Fresno. We see quite a few filed here in Kern County. They generally focus on the failure of an employer to provide rest breaks or meal breaks or failure to pay properly.
Okay. So again, those policies just remain important, keeping up with the current labor laws, things like that.
Keep everybody within the organization, from the payroll department, payroll administration, fully trained.
Okay. Sounds great. Jay Rosenlieb, Klein DeNatale Goldner, thanks so much for coming in and taking the time with us this
Thanks
morning.
for the opportunity.
We appreciate it. All right. We'll take a break, and we'll be right back with this more Strictly Business and the closing bell.
If your doctor needs